welcome to Crime in Court. My name is Heather, and this is an update in the Delphi case. Obviously, we are talking about Indiana versus Richard Allen, and we are searching for justice for Abby and Libby in the Delphi homicides. And in this episode, we're going to be talking about. I'm actually going to do a couple of things, but the main portion of this is going to be the memo of law to support the third party culprit defense. So, up first, I'm going to read a couple orders from Judge Gull. No surprise, denied. Um, so, whatever, there's that. I'm going to then read the memo, the Delphi, sorry, not the memo of law, where they're going to provide reasons why Richard Allen's attorneys should be able to include third party culprit um, evidence in the trial because that is their defense. And they're trying to, basically, she would be taking away their opportunity to defend him if they take it. Because let me back up. The prosecution, Nick McLeland, he filed a motion in limine, which is basically like you file motions before a hearing or before a trial to determine what evidence can and can't be excluded and things like that. So they argue those kinds of things. So he wrote a motion in limine, we read through it, to exclude anything that talked about Odinists, any of the particular names that have been called out in any of the Frank's memos or things like that, any particular other suspects, which you're taking away Richard Allen's right to defend himself by doing that. In my opinion, I don't think she can do that, but she's done a lot of things that I don't think she can do. So with Judge Gull, it's she's gonna have to put it in writing and write her reasoning behind it. And if she does deny it, I am sure it will get appealed somehow, some way. All right. So, and then I'm going to read through the latest, which is a letter that was just received regarding some transcript fees. So we'll get into that. So please hit that like button and let's begin. Let me shrink myself here and let's begin with this order. So Judge Gull on 8/16, the August 16th of this year, she submitted two orders or issued two orders for the defense for a couple of their filings. So let's read through them. All right. First one. The court, having taken defendant's motion to compel and motion for sanctions under advisement following a hearing conducted July 30th, and having reviewed the submitted exhibits and arguments of counsel, now denies the defendant's motion to compel and motion for sanctions, as the defendant has failed to comply with Trial Rule 26F in seeking an informal resolution of discovery disputes. However, the court will order the state to turn over Sergeant Cecil's report within 10 days of date of this order, and that any new discovery be provided within 7 days of receipt. The court further orders the parties to exchange a list of trial exhibits by October 1st. Okay, let's break this down. So first of all, we read through the motion to compel discovery and motion for sanctions because Nick McLeland he's playing dirty with the evidence. He is not turning certain discovery over. He's burying discovery within, just this whole unorganized mess of files that they have given like multiple data dumps with just a multitude of pages and things that they have to sort through, and it's overwhelming, and it seems almost like they're doing it on purpose. And they put forth a great argument regarding this. And you know what, I listened to, I believe it was Michelle After Dark. She did someone shared it, and I saw it somewhere, and I was like, oh, this is a really good video where she breaks down this whole Trial Rule 26F And she tells us when the defense was seeking discovery, how they communicated, when the communications occurred, in what manner they were occurring. She breaks it down and really tells you, like, well, they reached out this time and Nick McClellan said, nah, I'm not giving you stuff. So whatever, like she breaks it down and does a really good job talking about this trial rule 26F and basically proving that the defense did meet their burden in this uh, whatever, reading this trial rule, and they absolutely did try to get discovery on their own many times in the normal way lawyers talk back. Lawyers are supposed to get along. It doesn't seem that way from the trials we've been watching lately. But lawyers are supposed to be the adults, get along. They're supposed to be seeking justice. So they're supposed to work together. So the prosecution and the defense are supposed to be, at least working together to further along their case. But it seems like every turn they go, the prosecution is s- stunting the defense's progress in their defense, in putting forth their defense. So, anyways, so I don't think that they didn't comply or whatever this is. She's saying they didn't comply with this rule, which they absolutely did. Michelle After Dark had a video just recently. I can't remember what it was called. If I can find it, I'll put it down below in the description. Let me hold on. Let me write myself a note, or I will forget. Okay, I wrote myself a note. Are you guys like that? If I don't, either do it the minute that the thought comes in my head or write it down the minute the thought comes in my head. I totally forget. I've got ADHD so bad as my adult years have progressed. And yeah, that's why, I lose train of thought constantly in my stream. And I apologize for that. But, that's just who I am. And I'm not going to really, I'm sorry, not sorry, really, because it's just who I am. But I don't like that I do it, but it is what it is. All right. So moving on. Well, it is interesting too, before I move on to the next one. She makes the comment that, you guys, the defense, are in the wrong. You screwed up. You didn't comply with this rule. However, I noticed the state didn't turn over this particular thing. So, you know what? I'm going to force them to turn that over within 10 days. So she fails to say, like, her two comments, the top paragraph and the bottom of the paragraph are like two contradicting things. First, she's saying, you guys screwed up, you didn't meet the rule, you didn't meet your burden or whatever. And then she's saying, but just to be sure, I'm going to make sure that this document that you haven't got, this Cecil report, I'm going to give them 10 days to give it to you. So basically they got their she did compel them. So she's granting half of the motion, but she can't even give them that win. She says it's denied. She's granting half of the motion in full, or granting half of the motion by saying, Cecil has to turn this report over. She makes no sense to me anymore. I I don't make it a secret how I feel about Judge Gull. I cannot stand her. I think she needs to get off the bench. She's done. She's just done. She can't do this impartially. And if she's doing this for one case, how many other cases is she doing it to? So goodbye. Judge Gull has to go. All right. So the next issue or the next order that she issued was stating this. The court, having had the defendant's second motion to dismiss based upon newly discovered, destroyed, and/or missing exculpatory or potentially useful evidence under advisement following a hearing conducted on July 30th, and having reviewed the exhibits submitted and the arguments of counsel, now finds that the law is against the defendant. Well, surprise, surprise. So this is regarding they had put forth a second motion to dismiss because all these the interviews between law enforcement and Brad Holder, Johnny Messer, Patrick Westphal, all the people that, the defense or the prosecution doesn't want the defense to talk about, all of those people, they were suspects early on, and they were all brought into law enforcement office and interviewed by law enforcement. And oh, what do you know? Lo and behold, all of their interviews were taped over due to some kind of administrative error or something. Baloney. Get out of here, because that is a freaking lie. But whatever. I mean, they proved it in their, maybe not proved it, but they gave a lot of good reasons as to why they think it was, if not like just extremely negligent, it might have even been on purpose, that they would have destroyed exculpatory evidence towards Richard Allen, or exculpatory evidence of Richard Allen. So these interviews might exculpate Allen of these charges, but for some reason they all disappeared because it could inculpate some other people, and I think somebody's protecting somebody. Somebody in law enforcement is protecting them. Someone in unified command, probably, if you ask me. That's my guess. All right, so moving on, no evidence has been presented to the court that the state destroyed exculpatory evidence, nor that the state acted in bad faith. The defense argues that this alleged exculpatory evidence all relates to one person, Brad Holder. And it doesn't. It doesn't all relate to Brad Holder. There are multiple people that were mentioned. So obviously, this tells me that Judge Gull did not even read. She doesn't know anything about the Frank's memo other than Brad Holder's name is in it. Why is she protecting Brad Holder? Why is she pointing him out of all people? She's saying uh, the defense argues that this alleged exculpatory evidence all relates to one person, Brad Holder. When did they say that? But okay, Judge Gull, we know who you're protecting now, Brad Holder, for some reason. However, no evidence has been presented to support this argument, nor has any evidence been presented to negate the evidence offered by the state, which cleared Brad Holder of involvement in these crimes. No, no, no. We don't even know if they can be cleared. You can't say that they've been cleared because law enforcement says they're cleared with no evidence of any of their interviews. Bring them in, do a hearing, ask these people the tough questions, and let's find out where they were. Let's find out what their alibis were and how they know one another and all that stuff. I think it, that needs to be done because obviously law enforcement didn't do their job. Anyway, sorry, this case gets me passionate too. I get really passionate sometimes. However, no evidence has been presented to support this argument. Oh, I read that. Okay, so they haven't cleared or they cleared him supposedly, whatever. They also cleared, they come out and clear all these people early on, and I think that's really not a good way to go about it. I think everyone should be a suspect until they're not. All right, so the defendant's second motion to dismiss is therefore denied as unsupported by the law and the evidence. So she's saying they didn't meet their burden during the hearing because there was a hearing July 30th, 31st, and then August 1st. A 3-day hearing. They went over all the motions and they did bring in witnesses and things like that. So apparently, Judge Gull says they failed to meet their burden here. So she ordered a denial. All right, moving on to the memorandum of law in support of admission of evidence of alternative theories of the crime and third party perpetrators. So basically, let us talk about Odinists and other potential suspects. Other not just suspects, but people that are quite uh, quite good for being the guy or guys, multiple men, maybe. Maybe it was multiple people that did it, which we know even Nick McClellan thought that at the very beginning because we read through that transcript. They were on their November 22nd, 2022. hearing. This was the first hearing with Richard Allen's attorney, Brad Rosie, right when he was arraigned or whatever. It's shortly thereafter. It was one of their hearings. And Nick McClelland was still saying they strongly believe that there could be multiple people and that they are still investigating that angle. And they wanted to keep that open. So that was in 2022 still. They were still thinking that there could be multiple perpetrators. So for that reason alone, you should be able to bring in other possible suspects. Anyways, all right, so comes now Richard Allen by counsel and provides this memorandum of law in support of admission of evidence of alternative theories of the crime and third-party perpetrators. Introduction. Mr. Allen has a constitutional right under the 6th and 14th Amendments of the United States Constitution and Article 1, Section 13 of the Indiana Constitution to present evidence attacking the credibility of the prosecution's case, undermining the believability of the prosecution's witnesses, identifying third-party suspects, and establishing Mr. Allen's theory of the case. This right is the cornerstone of the adversarial process and essential to a fundamentally fair trial, and denial of this right constitutes structural error. And basically, they are saying he has all of these rights pertain to him getting a fair trial and being able to defend himself. And if that means putting forth other suspects, then he has a fundamental right to do that. And if she rules that he cannot, that is structural error and they need to overturn that. An appeals court would absolutely overturn that if they're not allowed their ability to defend themselves. And they've been putting forth all this information for so long, trying to defend themselves, Alan trying to defend himself, and Judge Gull keeps shooting him down. So it's very frustrating. All right, so this right is the cornerstone of the adversarial process and essential to the fundamental fair trial, and denial of this right constitutes structural error. Whether rooted directly in the Due Process Clause of the 14th Amendment or in the Compulsory Process or Confrontation Clauses of the 6th Amendment, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. A complete defense. Right there. Let's get my highlighter out. Yeah, we like to highlight. All right, so the right to this right is accomplished through the right to offer the testimony of witnesses and to compel their attendance at trial. So why there's like no in between. I want it just slightly bigger, but it won't. Too big. Okay, just leave it. Sorry, my eyes suck today. I'm having issues. So basically, they are saying it's Alan's right to call witnesses and basically force them to come to court and be scrutinized under cross-examination. So it is his right to do that. And by not allowing her to bring in these witnesses or cross-examine about these witnesses or about these people, it's going to be difficult for him to defend himself. It is necessary for both the accused and the prosecution to present their version of the facts to the jury so it may decide where the truth lies. It is not up to the judge to decide where the truth lies or what the version is that should be presented to the jury. It's up to the jury to decide. Give them all the information. Just as an accused has the right to confront the prosecution's witnesses for the purpose of challenging their testimony, he has the right to present his own witnesses to establish a defense. That is true. This right is a fundamental element of due process of law. So even if the state doesn't bring up any of these people in the Franks memo in their in their um, in their case, when they present their case, the defense has a right to bring those people in. Call in Brad Holder. Ask him, where were you? Did you have anything to do with this? Um, just like they did in the Karen Reid case, bring in all the suspects as witnesses, although the prosecution brought in all their witnesses and they were horrible for the state. But same kind of idea. If the state's not going to call the witnesses that, the Brad Holders and the Patrick Westfalls, then the defense has every right to call them for whatever reason to defend themselves. So it's or call in the Purdue expert on Odinism, who is the one that originally looked at the case file and said, yes, this could be consistent with an Odinist kind of practice and Odinistic type runes and things like that. So, yeah. All right. Moving on. So, when the prosecution seeks to prevent an accused the opportunity to present other versions or possibilities regarding the alleged crime, either through cross examination or his own witnesses and exhibits, they are urging the trial court to commit not only an evidentiary error, but a constitutional error from which prejudice is presumed. So not only are you violating the rules of evidence, but you're also just violating the Constitution. You are violating his constitutional rights, which is even worse than just, a little evidence, uh, whatever, even though that's bad too. All right, so similarly, exclusion of evidence tending to show that someone other than the accused committed the charged crime is inconsistent with substantial justice and therefore cannot be deemed harmless error. So, by not allowing him the evidence that other people may have been involved, justice is not being served, and it is, as they call it, cannot be deemed a harmless error. So it's not just, yeah, let's just, look the other way. It's fine. It's something that would be overturned for sure. All right, so thus this question becomes what type of evidence is so critical and unique to Mr. Allen's defense that the U.S. and Indiana constitutions above and beyond the Indiana rules of evidence require its admission? The Indiana courts have answered that question by reversing cases when the excluded evidence challenged the credibility of the state's investigation and witnesses. So any of that Odinist stuff, Todd Click, and anything that Greg Ferenczi did, even though he's deceased now, he's one of the three officers. So Greg Ferenczi, Kevin Murphy, and Todd Click are the three officers that were investigating the Odinist angle with kind of on their own without Unified Command's lead or telling them to. They were following the evidence, and that's where it led them to. So um, those people, those officers should be brought in to testify about that for sure. And the state's probably not going to call them, so the defense needs to be able to do that. All right, so the Indiana courts have answered the question by reversing cases, blah, blah, blah. Um, did I read all that? I don't remember. So the Indiana courts have answered that question by reversing cases when the excluded evidence challenged the credibility of the state's investigation and witnesses, presented an alternative theory, exculpatory explanation of the state's evidence, or showed that someone else could have committed the crime. So those are all the other reasons. Sorry, I cut myself off in mid-sentence. All right, so at the hearing, on the prosecution's motion in limine, Mr. Allen presented evidence that the homicides of Abigail Williams and Liberty German have ties to Odinism and were ritualistic. Mr. Allen also presented evidence that third parties are linked to the homicides. The prosecution seeks to exclude evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. The prosecution further requests an order to exclude testimony or evidence concerning A, Odinism, B, I'm not going to say AB. Sorry, so Odinism, cult or ritualistic KI double Elling, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Jerry Anthony Klein, and Ron Logan. Prosecution's request seeks to limit Mr. Allen's ability to present a defense and, if granted, violates Mr. Allen's rights pursuant to the 6th and 14th Amendments to the United States Constitution in Article 1, Sections 12 and 13 of the Indiana Constitution to confront and cross-examine witnesses and to present his defense. I think that was well worded. All right, so Mr. Allen is entitled to present evidence pursuant to the amendments and Constitution that the crime has elements of Odinism and ritualistic KI double Ellings. The 6th and 14th Amendments of the United States Constitution in Article 1, Section 12 of the Indiana Constitution demand that the jury hear all versions and possibilities regarding the alleged crime. The state cannot take advantage of the inculpatory conclusion but prohibits the defendant from placing the exculpatory conclusion before the jury. The state cannot take advantage of the inculpatory conclusion but prohibits the defendant from placing the exculpatory conclusion before the jury. Got it. Okay. It took me a minute. So the state can't just go ahead and present all this evidence that makes my client look guilty when we have all this evidence that makes my client look innocent, basically, to make that sound, to dumb that up, that sentence. Took me a couple tries to read through that. All right, so in this case, the prosecution argues that Richard Allen, acting alone, took the lives of Abigail Williams and Liberty German. However, the evidence from the location where the bodies were found strongly suggests that more than one person was responsible for these crimes. Former Indiana State Police Detective Kevin Murphy, one of the good guys, testified that it was always the belief of law enforcement that there were between 2 to 6 people involved in these crimes. If the prosecution's argument is that Richard Allen acted alone and there are alternative theories that the crimes were committed by more than one person, then who are the additional people involved in the homicides against Abby Williams and Liberty German? That's a good question. If there were up to 6 people and we only have one of them, where are the rest? Makes you wonder. The answer is that there are third-party suspects who have not been charged and who have no ties to Richard Allen. This leads to the conclusion that Richard Allen is innocent and that other individuals acting together took the lives of Abigail Williams and Liberty German. I was going to say something else and then it just, my thought just dissolved. I don't know what happened to it. All right, so never mind. Dr. Dawn Perlmutter, the director of Symbol Intelligence Group and adjunct professor of forensic medicine at the Philadelphia College of Osteopathic Medicine, and who trains federal, state, and law enforcement agencies, testified that the homicides were committed by individuals with ties to racist Odinism, sometimes also known as Asatru. And I'm going to stop right there and point out the word that she just said. This is exactly what these Odinist groups are. If you look at them, you can kind of tell. On the outskirts, they try to look and appear like this is a religion and they're worshiping the gods Odin and Thor and all those, mythological Greek um, gods. So they make it appear that that's kind of what they are worshiping. However, it's a very it looks to me like a SKIN head type of organization, a very racist, white power type of um, clan. And that is what they appear to be in like the prison systems and things like that. This Asatru and Odinism, while it seems to be a religion, it's really more of like the new, um, the letter K three times, pretty much. All right. So Odinism and Astru are polytheistic ideologies involving the worship of Nordic pagan gods, including Odin and Thor. And if you're thinking like, wait a minute, Thor from the Marvel movies and Odin, Anthony Hopkins, and um, the Hemsworth guy, that's Chris, right? Chris plays him. Yeah. So those are the gods that they are worshiping. Thor. Think about that the next time you watch a Thor movie. I love the Thor movies. They're funny. All right, so these ideologies are nature-based ideologies, and their rituals generally take place outdoors. They incorporate natural elements and are typically performed near natural bodies of water. Both ideologies incorporate the use of runes, which are marks of mysterious or magical powers. Runes take on additional magical powers when charged by BLOOD or when two or more single runes are coupled together to create a bind rune or a binding rune. Both ideologies also incorporate magical thinking. So it's kind of like it gives power, it's symbology. It's like, symbols have meaning to people. Letters, words are symbols, basically. Whoops. But, other objects and other things can be um, symbols as well. All right. So Odinists, Dr. Perlmutter further testified that while Odinists have general shared symbols, such as Odin's hammer, as they splinter off and form their own little clans or kindreds, she calls them, they often develop their own symbols and rituals. And these runes, I did a whole episode on what the runes were in, like the F rune. There's images of Patrick Westphal painting the F rune on a tree with BLOOD. And that was also at the scene. And the sticks on top of Abby and Libby were shaped in the shape of runes or formed in the shape of runes. So that would be, two runes together binding plus the BLOOD. So plus they're by water. All these things added up make it this like magical, symbolic event. And whatever it symbolizes this sacrifice that they're doing, if that's what it is, and this is what happened, and they sacrificed Abby and Libby for this purpose, then whatever that purpose is, like power, money, fame, riches, whatever it is, they all combined their energies and energy put forth in thoughts and actions can actually bring about things. So all their energy going into this symbol, meaning like they want riches, or let's say it's riches and fame and riches they want from this particular sacrifice that they do, and they put all their energy and thought into that, and then that's what that symbol represents to them, and all the magic, the the BLOOD, the water, being near water, being in nature, all of that combines to give their sacrifice more power, more meaning. It makes it more real, if that makes sense. It puts more power behind it, whatever their intentions are. All right, so social media has been a large part of this development as it allows individuals access to a wide range of interpretations, symbols, and ideas relating to Asatru and Odinism. Dr. Perlmutter testified that the homicides of Abigail Williams and Liberty German meet all of the elements of the ritualistic KI double Elling and was a textbook ritualistic KI double Elling. Sorry for all the dumb words I have to say in place of the real word because YouTube censoring, sorry. All right, so the elements of a ritualistic KI double Elling include one, the location of the crime. So this is what I was just talking about. The location of the crime. Dr. Perlmutter testified that Odinism and Asatru are nature-based ideologies. These homicides took place outdoors in a clearing in a wooded area near a body of water. Dr. Perlmutter testified that in Odinism and Asatru, clearings can be the location of a sacred circle where rituals and sacrifices take place. She further testified that it is important that the homicides took place near a body of water, as water is often used for purification prior to rituals or sacrifices. Not just that, but it magnifies the magic and the power that you have behind your intention, like I said. So they kind of left that out of this motion, but in these kinds of rituals, that is the case as well. All right, so the date of their demise. Dr. Perlmutter testified that often rituals and sacrifices take place on important dates. She testified that Valis Blot is a sacrificial feast. So, this Valis Blot is some kind of ritualistic ceremony or tradition. So, it's the sacrificial feast day honoring Odin's son Valis. So, they probably have traditions and things that they do on this day. What? I don't know, but they're calling it a sacrificial feast day. So that means probably you're supposed to do some kind of a sacrifice to Odin, whether that's a live sacrifice or, you give something up that you love or care about. I don't know. All right, so I have no idea. I'm just saying like as I'm seeing it or how it could be interpreted, but it might actually mean taking a life. I have no idea. All right, so this begins at sundown on February 13th and ends at sunup on February 14th. This is the exact day and time when they go missing. So they went missing in the afternoon of the 13th and they were found in the morning hours of the 14th in the location where they were. So that just makes it even more creepier and aligns with this theory. Number three, the cause of their demise. Dr. Perlmutter testified that ritualistic crimes are most often committed by sharp force injury to the neck. Okay, so trigger warning, trigger warning, trigger warning. I gotta put up a trigger warning. Where is it? All right, so graphic content common. All right, sorry about this. If you don't like to hear details and things like that, you might want to skip ahead a few seconds. All right, so the cause of their demise. Both girls, sharp force injury to the neck and slitting the throat is indicative of sacrifice and an initial ritual. Both girls were taken in this manner, meaning sharp force injury to the neck and then slitting the throat. Both girls had their throats slit, is what this is saying. So graphic content. Okay. So the weapon that was used, Dr. Perlmutter testified that ritualistic crimes are often committed with ritual or with ceremonial knives. The weapon used to take the girls' lives was a knife, according to the autopsy report. Oh, here. So autopsy of Roland Core. So it is not. Who's Gigi and HH? Defenses exhibit. Oh, those are the exhibit numbers. Okay, sorry. I that's who the autopsy was done by. Just wondering. I wanted to know who the medical examiner was. All right. So, symbols of crime scene. Dr. Perlmutter testified that in ritualistic KILLings, symbols, including runes, are often left at the crime scene. In this instance, there is what can be interpreted as a Leguse rune painted and transferred to a tree with Liberty German's BLOOD. So maybe that's the F rune or something. Maybe it's not an F and maybe it looks like something else. I'm not, or that's what it's called. I'm not sure. So the tree is located near the area where the girls' bodies were ultimately found and on the edge of a clearing. Additionally, Dr. Perlmutter testified that the sticks and branches laid on the bodies appear deliberately and intentionally placed in particular arrangements which would have meaning to the individuals committing the crime. So they definitely looked like they were purposely placed in a specific manner in order to make it look a certain way. So these sticks definitely looked deliberately placed and they would have a meaning. However, the whatever the placement was, it meant something to the perpetrator or perpetrators. All right, so FBI Special Agent Nicole Robertson testified that when she was searching the home of Ron Logan, she was looking for evidence of runes and anything Nordic due to the placement of sticks on the girls' bodies. So an FBI agent looking into this case was looking into Odinistic Nordic type angles because of the placement of the sticks. This is the FBI. Repeat, the FBI. The emails between FBI and State Police Superintendent Doug Carter all provide evidence of the belief of law enforcement that the evidence left behind at the crime scene, including sticks found on the girls, supported the possibility that the perpetrators were Norse paganists. Norse paganists, or Odinists, Asatru worshippers, whatever you want, Vinlanders, another name. Like they have all these different names for themselves, but I think they're mostly interchangeable. All right, so 6. Body disposition. Dr. Perlmutter testified that in a ritualistic KILLing, bodies are often moved and positioned in a fashion that is not a counter-forensic measure. In other words, that the bodies are moved and positioned in a manner not consistent with someone who is trying to conceal the bodies. So they were out in the open for anyone to find. She further testified that bodies are often positioned to include the arrangement of natural objects. In paragraph 6 of her affidavit for probable cause for the search warrant for the home of Ron Logan, FBI Special Agent Nicole Robertson testified that it was her belief that Liberty German and Abigail Williams' bodies had been moved and staged. Major Cicero of the LaPorte County Sheriff's Department also testified at the hearing that Liberty German's body was drug around the crime scene and that Abigail Williams was moved from side to side. So you have potentially evidence left behind or a scene that looks as if someone's body had been drug in the dirt and the leaves and the grass and whatnot, and then someone else might have been moved side to side, so you might see different drag marks or patterns in the ground. Additionally, it is evident from the crime scene photo identified as Exhibit FF that sticks and branches were deliberately and intentionally arranged on the bodies. Major Cicero testified that the sticks and branches maybe covered 3% of the girls' bodies. He further testified that there were many leaves and sticks in the area which could have been used to conceal the bodies if that was the intent. So he's saying the sticks were left out in the open. There's no mistaking that they were left out in the open. They were meant to be found. They weren't putting the sticks on top of the girls trying to hide the bodies, is what they're saying. It is definitely these sticks were purposefully placed in some sort of an arrangement, and the rest of the girls' bodies, I mean, they were out in the open and exposed to be found. So there's no question about that, according to this. All right, number 7, atypical BLOOD pattern. Finally, Ms. Perlmutter testified that there is often atypical BLOOD patterns identified in ritualistic KILLings. She identified the pattern on Liberty German's face as an atypical pattern. This abnormal pattern on Liberty's face was also identified by Major Cicero. So multiple people noticed this odd or abnormal BLOOD stain on Libby's face. Mr. Allen has a constitutional right pursuant to the 6th and 14th Amendments of the United States Constitution and Article 1, Section 12 of the Indiana Constitution to present evidence describing the area where the bodies were found, the manner in which they were found, and to provide an explanation for said description. So all of those things, the manner in which the bodies were found, how they were found, what the sticks looked like, all of that he needs to be able to present to provide an explanation. He didn't do this. Like, he had nothing to do with this. This has ties to somebody else, obviously. All right, so he further has, or well, I say obviously, but it's not obvious. All right, so it's not obvious to everybody. I'll say that. He further has the right to prevent evidence flowing therefrom that the individuals who took Abby and Libby's lives were followers of Asatru and Odinism, and that the crimes were part of a ritualistic sacrifice. He has a right to present that. Like, she shouldn't be able to stop him from presenting that or limiting it. Like, he has a right to put on his defense, and if that's what happened, that's what happened. He needs to say. All right, so the 6th and the 14th Amendments, blah, 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 protect Mr. Allen's rights to challenge the manner, quality, and thoroughness of the investigation, to inquire about law enforcement's right to consider third-party suspects, and to present evidence of a biased investigation. Mr. Allen has a fundamental right under the Due Process Clause of the 14th Amendment of the United States Constitution, the Confrontation Clause of the 6th Amendment of the U.S. Constitution, and the Article 1 and 13 of the Indiana Constitution to call law enforcement officers as witnesses and to cross-examine them. So this goes directly to Todd Click for somebody to talk on Ferency's behalf and Kevin Murphy, and to cross-examine them on third-party suspects as the failure to properly investigate. Well, they properly investigated. They have a right to call like Jerry Holman or Tobe Lesenby or any of the investigators in this that they want to, because if they want to question and cross-examine them to find out the validity of their testimony, they have the right to do that. So they have a right to cross-examine them on third-party suspects as a failure to properly investigate or consider third-party suspects undermining the thoroughness of the investigation. The fact that an investigator may have discounted a viable fact or suspect makes it more probable the investigation was flawed and that Mr. Allen is innocent, thus meeting the requirements of relevancy under Indiana Rules of Evidence 401 and 402. Mr. Allen also has a fundamental right to impeach the credibility of and present the bias of any witnesses, including law enforcement. Hello, Unified Command, we talking to you. A witness's bias, prejudice, or ulterior motives are always relevant at trial in that they may discredit her or affect the weight of her testimony. It has been well established that law enforcement, like all humans, can suffer from confirmation bias and tunnel vision. In other words, a detective or officer may search for and interpret evidence in a manner that confirms his or her existing beliefs. In this manner, Mr. Allen's evidence is that law enforcement failed to properly investigate third-party suspects and failed to consider alternative theories to their timeline. In this case, members of Unified Command failed to follow up on the leads, and investigators of Assistant Police Chief Todd Click and Indiana State Police Detective Kevin Murphy such as the failure to perform an extraction of Brad Holder's phone, the failure to investigate the alibi of Patrick Westphal or Elvis Fields, and the failure to seek warrants to search the homes of these individuals. Unified Command did not consider any fact that did not fall into their own timeline that the girls were taken and their lives were taken between 2:14 and 3:30 p.m. on the 13th. Unified Command failed to investigate why Liberty German's cell suddenly connected to the cell phone tower at 4:33 a.m. on February 14th. So this was new information that came out in this hearing. So um, Liberty's phone connected to a cell tower at 4:33 a.m. on the 14th after not connecting to the tower from 5:44 p.m. on the 13th. So it stopped connecting. The last connection it had to that cell tower there was 5:44 p.m. And then it came in at, or then at 4:33 a.m. it got another, or it got connected to the phone tower again, which in my mind makes it seem like somebody did that. Somebody turned her phone off or put it in airplane mode or something. Indiana State Police Detective Jerry Holman testified that there was no evidence that Richard Allen returned to the location where the bodies were found after 3:30 p.m. on the 13th. So he didn't turn it off and turn it on. Something happened at 4:33 a.m. on February 14th that caused Liberty's phone to suddenly connect to the cell phone tower, and it is logical to believe that whatever caused the phone to connect was the result of actions taken by a third party suspect. This evidence goes to the very heart of the thoroughness of the investigation into the demise of Abigail Williams and Liberty German. Mr. Allen's constitutional rights require that this evidence be admitted. And I'm going to break right here to take care of the dogs because they're begging to go out, and I will be right back. Don't go anywhere. Thank you. Sorry about that. All right, well, let's just keep going. All right, so his amendment rights also protect Richard Allen's right to present evidence that someone else committed the crimes. So, evidence is relevant when it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Evidence which tends to show that someone else omitted the crime logically, I mean, that's supposed to say committed. Evidence that tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime and thus meets the definition of relevance in Rule 401. In order for a defendant to admit evidence that a third party is responsible for the crime, the defendant must show connection between the third party and the crime. So, I think the defense have shown many connections as to the third parties in this crime. And I'm going to do an episode soon. I've already worked on the PowerPoint. I'm going to do a presentation on the who's who of Delphi. So if you are not subscribed or you want to know more, make sure that you are subscribed and hit that like button so that YouTube will make sure that you see my video when it comes out. All right, so when the state excludes competent, reliable evidence that is central to the defendant's case, his constitutional right to present evidence is abridged. When a state excludes certain things, then basically the defendant's right is infringed upon. All right, so Indiana courts have found the following evidence to be competent and reliable evidence central to the accused's defense that someone else did it. For instance, in this other case, Allen versus State, the defense provided a reconstruction of the crime and testimony that another person made statements linking himself rather than the defendant to the homicides which should have been admitted. So this statement that linked someone else to the crimes should have been admitted in his trial, in this Allen versus State trial. In Joyner versus State, another trial, evidence that a married man was having an affair with the victim worked at the same place as the victim. The defendant had intimate relations with the victim the night before the homicide, lied to his wife about his whereabouts, had an argument with the victim on the last day she was seen alive, and lied on on his time card at work the day after the homicide. All of those things were admissible in that Joyner versus State. In Rohr versus State, evidence that a prior beating of a child victim by mother, not defendant, caused victims extensive injuries was admissible. So, evidence from a prior incident where the mother caused physical harm to the child, and that proved that it wasn't the defendant in the case, or it went to show that the propensity for someone else to have done it, not not the defendant. All right, so evidence of a newspaper article with a picture of a person wanted in connection with burglaries in the area and who resembled the defendant was admissible. Understanding the evidence of third-party suspects is relevant. The question that turns to the standard the court must utilize in determining whether the third-party evidence is admissible. Why is my phone ringing? Hold on one sec. Some number, I don't know. All right. As the Indiana Court of Appeals has stated, to be admissible in a criminal prosecution, evidence that a third party has committed the crime with which the defendant is charged need to show substantial proof of a probability that the third person has committed the act. It need only be capable of raising a reasonable doubt of the defendant's guilt. Think about the Franks memo. Think about the things that have been stated in the Franks memo and the things that have, that have come out through that, the evidence through that. Uh, to me, that gives me enough reasonable doubt that Richard Allen may not have done it, which if I had to vote now, I would vote not guilty. While a criminal defendant may present alternative perpetrator evidence at trial in order to cast doubt on the defendant's guilt, the defendant must first lay an evidentiary foundation to establish that the alternative perpetrator evidence has an inherent tendency to connect the alternative perpetrator to the actual commission of the crime. I'm going to say right here there is a connection between the Odinists and Abby and Libby, but not Richard Allen and Abby and Libby, or Richard Allen and the Odinists. So he is a completely separate entity out of all the other players in the case. All right, so moving on here, Mr. Allen's evidence of third-party suspects falls well within the category of competent, reliable evidence central to his defense that he is innocent and that other people committed the homicides. Mr. Allen's evidence has an inherent tendency to connect the third-party suspects to the commission of the crime. And now we're going to get into all the people that are listed. So bear down, Chicago Bear. Sorry. My hair keeps getting in my face. It's annoying me. There, I think I got it. All right, so Brad Holder. He is the father of Logan Holder, who was Abigail Williams' boyfriend at the time of the homicides. That, my friends, is a connection, and it's not that difficult. It's not that far removed. It's the boyfriend's father. Law enforcement identified Brad Holder as a suspect by February 17th, 3 days after the bodies were discovered. Law enforcement received several tips that Brad Holder was the man in the video found on Liberty German's cell phone, purportedly taken at the south end of the Moden High Bridge at 2:13 p.m. on February 13th, 2017, and that he was involved in the homicides. In the first interview with law enforcement on February 17th, 2017, Brad Holder told officers that he had never met Abigail Williams. In his second interview with law enforcement on August 30th, 2023, Brad Holder claimed that he had difficulty remembering which girl that Logan dated, despite the fact that the girl Logan dated had been involved in a high profile homicide case right in his own very town. In this second interview, Holder now remembered that he had supervised one date between Logan Holder and Abigail Williams. So it went from I never met her to, oh, maybe I supervised one date with them. Brad Holder then told a third different story to as as to how many times he had met Abigail Williams. So he told a different story the third time when he was deposed on May 2nd, 2024. So May 2nd of this year. In his deposition, Brad Holder claimed he had met Abigail Williams twice, including once at a third-party suspect's house, and this other third-party suspect is Patrick Westfall. It is also important to note that Pat Westfall never admitted to the police that Abby Williams had been to his house. So Brad says, oh yeah, I might have seen her at Pat Westfall's house. And Pat Westfall says, nope, never been there. So, all right, so Richard Allen has a right to have the jury consider the following about Brad Holder's second statement on August 30th, 2023, and whether his second statement and his deposition 9 months later, both providing different accounts of his interactions with Abigail Williams, tend to show that he is a third party suspect. Number one, whether Holder lied in his first interview on February 17th, 2017, to inoculate himself against being a suspect by denying having met Abigail Williams. This is consistent with his statement in August 2023 when he stated he had met Abigail Williams and with his deposition testimony that he met her twice. Okay, so we've got some inconsistencies and his story keeps changing and expanding the more time goes on. The validity or lack of validity of Brad Holder's initial claim that he had never met Abigail Williams in his February 17th, 2017 interview 3 days after she was found. So the first interview took place immediately after the homicides, by the way. And Brad Holder was a suspect, and so were these other individuals, Elvis Fields, Johnny Messer, all of them were brought in and questioned early on in the investigation, 3 days, as early as 3 days into the investigation. But all their interviews went missing or got recorded over, is what they're saying. So, anyways, but then somehow he was able to remember 6 years later that when interviewed on August 30th, 2023, that he had in fact met Abigail Williams one time. Number three, the likelihood that in 2023 Brad Holder would not know which of the girls that were killed were the ones that his son was dating following the media coverage from the high profile case, or whether his claim to not remember which girl his son dated was simply another attempt at Brad Holder to feign ignorance of his knowledge of Abigail Williams to throw law enforcement off the scent. So he's pretending, I don't know her, never met her, so law enforcement stays away from him. The likelihood that Holder's ever changing stories of meeting Abigail Williams, including his last story that he met her twice, once at Pat Westfall's house, is indicative of a man who can't keep his story straight and only changes his stories because he is unaware of law enforcement evidence of those meetings, causing Holder to step closer to the truth with every account he tells. I like the way they worded that at the end. And finally, why would Pat Westfall choose to not tell law enforcement that Abby Williams had been to his house, as Brad Holder claimed in his deposition? And does such omission show that Westfall was concerned about being connected to Abby Williams? Was that consciousness of guilt that he deliberately didn't talk about Abby being at his house? In the course of the investigation, law enforcement found that Brad Holder posted many pictures of runes on Facebook and discussed their symbolism and magical powers. His Facebook posts indicate that he believes in the magical powers of runes. Even more revealing are Brad Holder's own words, in which he admits that runes had magical properties. Brad Holder liked a uh, in case anybody's wondering what a rune is, I did a whole episode on this, but they're they're like little stone. Well, we used to have. They're kind of like a way to fortune tell or to help you, like interpret messages. And each of the runes means something different and symbolizes something different. And when you put them together in certain order, or you can read them like tarot cards, um, it tells you, it gives you answers to like questions that you seek, basically. So that's what I understood runes to mean. But I mean, they do go back far in our history and were used for that, for fortune telling and whatnot. But apparently, they also mean some other things to some Nordic pagans who practice Odinism. They might mean a little something different, or just, I don't know. They have more symbolism than we thought. All right, so Brad Holder liked a post describing an outdoor sacrifice with a rune painted in human BLOOD on a tree. Brad Holder also posted a picture on Facebook depicting a scene eerily similar to that of the bodies when they were found, like positioned and staged the way that the girls were staged. He intentionally inscribed a temporary tattoo on his hand in a pattern similar to the sticks and branches placed on Abigail Williams. Even retired Indiana State Police Detective Kevin Murphy admitted that the sticks placed on Abigail Williams' body matched the temporary tattoo that Brad Holder inked on his hand just a few weeks after the girls were um, taken. Furthermore, Holder painted and then posted a picture of Odin's sacrifice, in which a Norse pagan god, Odin, is hanging upside down and one leg is bent in such a manner that his foot is resting against his calf. It's similar to like the hanging man in tarot. So the position of Odin's leg, but it means something else probably because of the Odinist stuff. But I don't know what it specifically means, but this position of Odin's leg in Brad Holder's painting is almost exactly the same position in which the perpetrators placed Abigail Williams' legs. So she had I'm going to show you a picture. 1 second. All right, so here I put up a picture that's kind of what it looks like. It's the Odin hanging from a tree. All right. Anyways, um, back to where we were. So the position of Odin's leg in Brad Holder's painting is almost identical to how Abby's leg was positioned. So just like that picture that I just showed you. So Brad Holder believes in the power of magic and BLOOD as it relates to magic. This is evidenced by his Facebook posts as well as Amber Holder's testimony. The Brad Holder intentionally cut his hand and allowed the liquid to drip on his Odin altar. Amber Holder testified that Brad Holder took her hand and cut her hand to do the same thing onto the altar. Major Pat Cicero testified that the marking found on the tree near the bodies was transferred to the tree with Liberty German's BLOOD. Dr. Perlmutter and Major Cicero testified that the marking on the tree appeared to be an upside down L. Dr. Perlmutter testified that this resembles the rune Laguz. Let me see what that looks like. Hold on. Look at the internet, but I wasn't prepared. Hold on one second. All right, so this is what the Laguz rune actually looks like. So it does look kind of like an upside down L or even like a backwards 7 kind of. Um, so the meaning of Laguz is water. The letter sound is L. It has a couple different deities that rule it or something. I don't know. Planet comes from the moon. The tarot is the star, whatever this means. So upright, it means balance, intuition, justice, clairvoyance, and relationships. So that's the meaning of this rune that was painted on the tree. Reversed means procrastination, self-doubt, and fighting fears. So in the upright position, it would, be fair to say like the opposite of those things. So it would bring more balance and whatnot to their lives. I don't know. So that's the Laguz. I don't even know if I'm saying that right. What does it say? The rune Laguz symbolizes water and thus the basic energy, the origin of all life, from which all living things on this earth arise. The Laguz rune stands for the subconscious and for immersion in the soul. In the inner self, every moment should be lived and enjoyed to the fullest. Attention should be paid to the inner voice. Under no circumstances should one hide the subconscious and with it dreams or face them with ignorance. Water means emergence, in this case, the emergence of desires. Well, that's kind of telling. So that's the Laguz root, which they found on the tree when with Libby's BLOOD. All right, so where was I? Dr. Perlmutter testified that runes charged by BLOOD carry additional importance in magical powers, and that this liquid is the highest offering to the gods. Shedding that liquid and sacrificing someone's life, animal, human, whatever, is the highest offering to the gods in this religion. The Norse pagan ritual videotaped by Brad Holder in Fort Wayne clearly showed Pat Westfall using his hand to mark a tree in some fashion similar to the Facebook post reference earlier, which was marked with human BLOOD and which Brad Holder quote unquote liked on social media. So Brad Holder testified that one of the times he met Abigail Williams took place at the home of third-party suspect Patrick Westfall. Amber Holder, Brad Holder's ex-wife, testified that Brad Holder told her that Patrick Westfall and his crew took the lives of Abigail Williams and Liberty German. Richard Allen has a Sixth and 14th Amendment right to present to the jury these facts and to argue that Brad Holder was pointing the finger at Patrick Westfall to either A, insinuate himself as a suspect by implicating Patrick Westfall, or, insulate himself, not insinuate himself. That didn't make sense. Insulate himself, like protect himself from being a suspect by putting Patrick Westfall in the mix as a suspect, or that B, Patrick Westfall, who had no real alibi, actually took the lives of those girls, and Brad Holder knew it and wanted someone to know in the event that Holder was ever accused of the homicides, or C, that Patrick Westfall, acting in concert with Brad Holder, had the girls abducted while Holder was at work awaiting Holder's arrival in Delphi later, at which time they took the lives of the girls. This is what I think happened. This is my theory of what I think happened. That somebody abducted them, waited around until later, till sometime at night in the dark. They brought the girls back to that area, or they might have taken them to some other area where the crime scene occurred or the crime happened, the homicides happened, and then they drag their bodies there somehow. But it makes sense to, you know, do more investigating on that because the place where they were found was not the crime scene. There was no BLOOD anywhere. And so it seemed like that might not be the place that that their lives were actually taken. Anyways, all right, so the facts and arguments, along with the knowledge that both Holder and Westfall were North paganists, and the belief of law enforcement and expert witnesses that the crime scene was filled with Norse pagan elements, all tend to show Brad Holder and Patrick Westfall took the lives of Abigail Williams and Liberty German, and therefore this evidence should be presented to the jury. Consistent with the low bar required to honor a defendant's constitutional right to present third-party suspect evidence, Amber Holder's August 1st, 2024 testimony exhibits an inference that Brad Holder and Patrick Westfall were involved in the crimes. Amber Holder testified that she is Brad Holder's ex-wife and that Brad Holder confided in her that he and Patrick Westfall had a falling out over something that happened in the woods near a river involving BLOOD. Furthermore, Amber Holder testified that Brad Holder confided to her that Patrick Westfall and his crew took the lives of the girls because of Westfall's belief that Abigail Williams' mom was a race traitor, meaning Abigail's mom may have been dating someone of a different race. So down here it says a race traitor is a person who supports attitudes or positions that are against the interests or well-being of their own race. So maybe she was supported Black Lives Matter and they didn't like that. I don't know. Whatever perceived crime. I told you these Odinists are it's just another word for SKIN head. So because it's about white power, I guess. Dr. Perlmutter also testified that individuals adhering to the white nationalist version of Odinism would take the lives of others because of the belief that someone was a race traitor. So definitely, uh, this could be a motive that someone was supporting another race, and that's why they found it to be offensive for whatever. Okay, just their own reasons. All right, so furthermore, Amber testified that Brad Holder told her that Westfall wanted to move on from animal sacrifices to human sacrifices, and that this was the real source of the falling out between Holder and Westfall. In his deposition, Holder denied ever making any of these statements to Amber Holder. Brad Holder's denial of uttering those statements to Amber makes Holder's statements subject to impeachment at trial. He's right. The statements that contradict one another, he should be able, Richard Allen's team should be able to bring that in at trial, question him, and figure out, try to get to the bottom of the truth, anyways. All right, so Brad Holder's alibi is in question because of 4:33 a.m. phone activity. Detective Jerry Holman testified that Brad Holder had an alibi as he left work at 2:45 p.m. on February 13th, 2017, and was 40 minutes away from the Monon High Bridge. First, Sergeant Chris Cecil of the Indiana State Police testified that the phone ultimately found under Abigail Williams' body did not receive any SMS messages from 4:06 p.m. on February 13th until 4:33 a.m. on February 14th. Like we said earlier, the pings, somebody turned the phone off and then back on. And it's very interesting that Libby's phone was found under Abby's body. This suggests that Libby German's cell phone was not connected to the cell tower at that time. Law enforcement's claim is that the phone had remained under Liberty German's body Oh, so now they're saying it's under Libby's body. I'm confused. There's a typo or an error there. All right, so law enforcement's claim is that the phone had remained under Libby's body from 3:30 p.m. on the 13th until it was found on around noon on the 14th. So they were found around noon the next day. Sorry. I think I said morning. All right, so however, cutting against that theory is the fact that a police report references Sergeant Mitchell Blocher's belief that the phone, as of around 10 p.m. on February 13th, was either no longer in working condition or that it was out of the area. So it was not able to function or it was out of the area. But we know that it was able to function at 4:33, so it had to be out of the area. Therefore, the police report supports the fact that the cell phone was out of the area for a period of time. In further support that the phone was out of the area is the fact that from 5:44 p.m. on the 13th until February 14th, the phone in question did not connect to the tower in spite of law enforcement's claim that the phone had never moved under Libby's body from roughly 3:30 p.m. on the 13th until the girls were found until the 14th. Libby's phone received no SMS messages from 4:06 p.m. on the 13th until it suddenly received 15 SMS messages at 4:33 a.m. on the 14th. Again, this most likely means someone turned the phone on. It defies all logic that 15 individuals suddenly sent excuse me, suddenly sent SMS messages to Liberty German's phone at 4:33 a.m. on February 14th when she had been missing for over 14 hours. When Liberty German's phone once again connected with the tower, as Chris Cecil finally admitted during his testimony, of all those messages awaiting Liberty German's cell phone to connect to the tower, finally matriculated onto her phone at 4:33 a.m. So all those all those messages from people going, "Where are you? We can't find you. Are you okay?" All those messages come dinging into her phone at 4:33 a.m. Why? Somebody turned her phone on at that time or took it out of airplane mode. So Jerry Holman testified that in law enforcement's theory of events, Richard Allen never returned to the crime scene after he left at around 3:30 p.m. So Richard Allen did not turn her phone on at 4:30 in the morning, or turn it off for that matter either at 4 something, 5 o'clock. Therefore, who could have been at the scene at 4:33 a.m. to turn the phone on? If Abigail Williams and Liberty German had their lives taken around 4:33 a.m. on February 14th, Brad Holder's alibi for 3:30 p.m. on February 13th is meaningless. And that's what I've been thinking too, because the timeline that the prosecution is giving us is meaningless. So Brad Holder's alibi is meaningless because he says he was at work when the crimes occurred, but the defense's theory is that the crimes occurred later. So they need to be able to present that at trial. That's his alleged alibi that he was at work anytime at workout anytime. He worked at a gym, workout anytime, I guess, and he was there at 2 a.m. Why was he at the gym? This is another weird thing. He went to the gym, and that's not a normal time that he ever went to the gym. So, I don't know. There's a lot of shady stuff happening in the Brad Holder, Patrick Westphal camp. These phone issues are a major problem for the prosecution's contention that Richard Allen acted alone and had left the area where the bodies were found by 3:30 p.m. on February 13th. and certainly provide the minimum nexus along with the other evidence detailed herein required to clear the hurdle that allows third party suspect evidence at trial. Brad Holder is connected with other suspects in this case. One of those suspects is Patrick Westfall. And so now we're moving on to him. Patrick Westfall was at home near the Monon High Bridge on the 13th with his son, Nick. Patrick Westfall was interviewed on the 27th of August in 2023, and that's where that came from. There is no proof of Westfall's whereabouts on the 13th other than his statement. To date, law enforcement has provided no concrete evidence of Westfall's whereabouts on the 13th. Brad Holder and Patrick Westfall knew each other from an Army deployment in Afghanistan. Patrick Westfall and Brad Holder practiced acid-true. Patrick, sorry, that's just the citation. They were members of a small kindred or clan, which I'm calling it a clan or a crew, which is a group of people who believe in Asatru and who gather to hold meetings and worship the gods. So basically, like their congregation, I guess. Patrick Westfall is a priest or holy man in the Asatru religion and hosted kindreds at his home in Delphi on Sundays. Brad Holder attended these meetings weekly. So that's how close they were. They saw each other at least weekly, if not more. Holder and Westfall attended a pagan ritual videotaped by Brad Holder in 2016 in Fort Wayne, Indiana, which was entered into evidence. Near the end of the video, Patrick Westfall appears to be marking the tree with his hand. Major Cicero certified that a tree at the crime scene was marked with a BLOOD of Liberty German. Dr. Perlmutter testified that the mark was in the form of a rune. Major Cicero admitted that whoever sliced Liberty German's throat could have Liberty German's liquid DNA on their hands. Tired of saying BLOOD. I don't know. It's so annoying. All right, so the forensic pathologist who conducted the autopsy admitted that upon slicing Liberty German's neck, again, trigger warning, guys, sorry, the amount of BLOOD and the force of that BLOOD exiting Liberty's neck upon slicing it would have been very powerful, squirting as far as 4 to 6 feet, no problem, according to, who was that? The forensic pathologist. Therefore, the jury could conclude that upon slicing her neck, the BLOOD forcefully covered the perpetrator's hands, who then used the BLOOD to mark the tree. I mean, it's common sense. All right, so Patrick Westfall told police that he had sacrificed a chicken by cutting off its head. That was in his interview on August 17th, 2023. Again, why did they bring them back for more questioning after they had Richard Allen in custody? That's what I want to know. Dr. Perlmutter testified that sacrifices are almost always carried out by slitting the throat of the animal or person being sacrificed, and furthermore that practitioners of these religions often begin with animal sacrifices. As mentioned earlier, Amber Holder testified that Brad Holder stated that Patrick Westfall wanted to elevate from animal sacrifice to human sacrifice. Furthermore, Patrick Westfall acknowledges that Asatru worship takes place in a clearing in the forest. This is consistent with Dr. Perlmutter's testimony that rituals will occur in open spaces in the forest. Both victims in this case were found in a clearing in the forest. This creates an inference that Patrick Westfall was involved in the homicides of Abigail Williams and Liberty German, and that they were sacrificed in an Asatru Norse pagan religion. All right. Moving on to Elvis Fields. I need to stretch. All right, Elvis Fields, a Rushville, Indiana resident, is a suspect in this case who was investigated by law enforcement. There is no doubt that Elvis Fields knew of the existence of Brad Holder. He admitted as much in his deposition. Additionally, Detective Kevin Murphy testified that Brad Holder can be linked to Elvis Field through Facebook posts, and that Elvis Field's Facebook posts mimicked those of Brad Holder. So they were friends on Facebook. Elvis constantly recreated or mimicked Brad Holder's posts. Elvis Fields testified in his deposition that Brad Holder frequently mimicked his Facebook posts when he posted pictures with knives, brass knuckles, sticks in the woods, and other items. It is a logical conclusion that Brad Holder knew Elvis Fields in some manner if he was mimicking Elvis Fields' Facebook posts. It would be exceedingly rare for a stranger to follow someone's posts and even rarer to mimic them, especially when both were suspects in the homicides of Abigail Williams and Liberty German. Former Rushville Assistant Police Chief Todd Click testified that Elvis Fields was a suspect or accomplice in the homicides and that he was interviewed several times by law enforcement. So Todd Click, one of our good cops, said in testimony that he believed Elvis Fields was potentially a suspect or an accomplice. After one such interview in which law enforcement collected a buccal swab from Elvis Fields, Detective Kevin Murphy drove Elvis Fields home. Detective Murphy testified that after Elvis Fields got out of the car, he returned and asked Detective Murphy if his spit was found on one of the girls, but he could explain it away, would he still be in trouble? And I'd like to ask, how the F would you be able to explain it away? Just how? Yeah, you can't. Elvis Fields lived in Rushville. He testified that he was at home in Rushville on February 13th. He denied ever being in Delphi. If he spits on one of the girls, this places him in Delphi at or around the time of the homicides. Elvis Fields' statement is admissible pursuant to IRE 8033. Then existing mental, emotional, or physical condition. Under this rule, a statement of the defendant's then existing state of mind, such as motive, design, intent, or plan, or emotional, sensory, or physical condition, such as a mental, feeling, pain, or bodily health, is admissible as an exception to the hearsay rule. Elvis Field's statement is clearly indicative of a guilty state of mind and indicates that he has a mental feeling of anxiousness over his conduct and possible ramifications. Additionally, Elvis Fields denied making said statement to Detective Murphy, and that was in his deposition. It is expected that Elvis will come to deny will deny asking the question at trial, thus making it improper impeachment evidence. This statement is also impeachment evidence contradicting Elvis Field's statement that he was never in Delphi. Finally, Elvis Field's question to Detective Murphy was previously that a question. Hearsay is a statement that one is not made by the declarant. Okay, so hearsay, it shouldn't be considered, it shouldn't be hearsay, period, but it definitely shouldn't be considered because of the fact that it's a question. So the hearsay is a statement that one is not made by the declarant or the person saying it while testifying at the trial or hearing. So um, if Alec Murdaugh's, goes on the stand and he's saying specific things he said to someone, that's not hearsay. And then two is offered in evidence to prove the truth of the matter asserted. So you're offering it just to prove the truth, not to or to bolster your whatchamacallit, because it supports the truth of the matter that you're trying to assert in your testimony. So a statement is a person's oral. Did I read? Oh, okay. So that was either or. I thought there was a third one. Never mind. A statement is a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. The hearsay rule does not bar commands, requests, or questions. Rod Abrams is a friend of Elvis Field's. In his statement to police, Rod Abrams testified that in the time at the time of the homicides, Ned Smith is Ned Smith, Elvis Fields, and Rod Abrams they all hang out together in the Rushville area. I believe Rod is Elvis's roommate, and then Ned is like a father figure to both of them, but really he's like really taking Elvis under his wing or something. I think if I have it all right, all three of their names confuse me. I get them messed up. But anyways, so Rod Abrams stated that at the time of the homicides, Ned Smith drove a white pickup truck, and that also sometimes Elvis Fields drove a white pickup truck. Tina Garrison saw a white truck parked at the old CPS building near the Moden High Bridge Trail at approximately 4:20 on the day of the homicides. This Tina Garrison report was tendered near the end of the day as an exhibit on August 1st in their 3-day hearing that they just had. Given that both Elvis Fields and his friend Ned Smith drove white pickup trucks, this potentially places them in Delphi near the scene of the crimes on the 13th. But Detective Murphy also testified that an analysis of Elvis Fields' cell phone records established that Elvis Fields used his phone often throughout the day, throughout any typical day. Strikingly, Detective Murphy testified that on February 13th, Elvis did not use his phone between roughly 10:30 and 7:30 p.m. 10:30 a.m. to 7:30 p.m. All of the above is documented in Todd Click and Detective Ferenczi's reports. Statements made in the police report are not hearsay when offered to show the simple fact that the statements were made rather than for the truth of the matter. So basically just to know, to put forth what people's, um, I don't know what I'm saying. Statements made in a police report are not hearsay when offered to show, okay, so usually they are, but when offered to show the simple fact that the statement was made. So if you're trying to impeach someone and say, Joe Smith didn't say that he told his wife that he was out at the bar with some buddies, and he told one of his buddies that he was out on a date with his wife, and his stories contradict. So you're able to bring in that, uh, sorry, that the police report saying that because you're trying to assert that it was said, not the truth of it, but just the fact that it was said. That makes sense. All right, so where are we? Finally, the fact that Elvis's friends, Rod Abrams and Ned Smith, could not keep their story straight concerning their whereabouts with Elvis Fields on February 13th is also important. According to Todd Click and Detective Kevin Murphy, Abrams told different stories as to his whereabouts with Elvis on February 13th. In one story, Abrams claims he, Elvis Fields, and Ned Smith were all in a Muncie hospital visiting a friend on February 13th. In his interview in 2018, Abrams admitted having his phone with him while in Muncie on February 13th. However, when pressed whether his phone's pings would verify that he was in Muncie at that time, Abrams stated that the hospital equipment would likely block his phone's location. So I'm trying to get ahead of, oh, well, you might not see my ping because it might be blocked from the from the hospital equipment, which is ridiculous because you have your phone on you all the way up until you go to the hospital. So it should be pinging on the towers all the way to when you get to the hospital and when you go back from the hospital. So all that should be able to be captured. During his deposition, Rod Abrams testified that he did not believe he even owned a phone in 2017, which is a different story than what he told a few years earlier. While Abrams and Smith claim that Elvis was with them in Muncie on February 13th, Elvis Fields denies that he ever had left his house in Rushville on that day. Yet again, Detective Murphy testified that Elvis Fields' phone records show that the man who constantly used his phone on any given day for some reason did not use his phone between roughly 10:30 and 7:30 a.m. on February 13th, a period of 9 hours. By Google Maps, it is roughly a 2-hour drive from Delphi to Rushville, giving Elvis plenty of time to leave his phone in Rushville, drive or be driven in a white pickup truck to Delphi to participate in the homicides, and then return to Rushville. Plenty of time, right? These changed and inconsistent stories related to Elvis Fields' alibi, as well as to Elvis's phone activity for February 13th, provide further inferences or connections between Elvis and the homicides and other third-party suspects. So this ties Elvis to the crimes. Furthermore, while Johnny Messer admits to knowing Elvis Fields, Rod Abrams, and Ned Smith, that is not the story that Elvis Fields and Rod Abrams told to police. Both Elvis and Rod deny knowing Johnny Messer. These points were made in documents provided to the court, along with the notes that pointed to the specific pages or start that sentence over. Tongue's getting tired. This is a long doc. These points were made in documents provided to the court, along with the notes that pointed to the specific pages or timestamps on the items. These inconsistencies and denials provide evidence that the parties can't keep their story straight on something as basic as whether they know each other. These discrepancies could certainly be viewed as by a jury as attempts by guilty parties to hide their connections in order to deceive law enforcement and to deceive the jury and the jurors. The inconsistencies and discrepancies concerning their alibis and whether they even know each other are examples of things the jury could or should hear concerning third-party suspects. These discrepancies, combined with Elvis Fields' clear connection with Brad Holder through Facebook and Elvis's incriminating question to Murphy, support Elvis's question about the spit, support Richard Allen's 6th and 14th Amendment rights to pursue these third-party suspects. Johnny Messer, nope, we still have a ways to go, so we might have a couple more. Johnny Messer, a former Rushville resident, is also a suspect in the case who connects the Logansport and Delphi crew of Brad Holder and Patrick Westphal to the Rushville crew of Elvis Fields, Rod Abrams, and Ned Smith. So the Delphi crew, Logansport Delphi crew, are the Brad Holder, Patrick Westphal, and whoever else is there. And then this other Rushville crew is Elvis Fields, Rod Abrams, and Ned Smith. There are pictures on social media of Brad Holder, Patrick Westphal, and Johnny Messer going together at an Odinist gathering. The photo was admitted into evidence on August 1st of this year, and both Kevin Murphy and Todd Click testified as to the connection between Brad Holder, Patrick Westphal, and Johnny Messer. Detective Murphy and Todd Click testified that Holder, Westphal, Messer were all associated with the Vinlander Social Club. Hereinafter, Vinlanders, a club for Europeans, as explained by Patrick Westphal. Johnny Messer was a probate with the Vinlanders. Detective Murphy and Todd Click testified that the Vinlanders engaged in Asatru-based practices, worshipped gods such as Odin and Thor, and were Odinists. Johnny Messer confirmed that most members of the Vinlanders were into Odinism. Patrick Westphal and Johnny Messer traveled to Minnesota together for a Vinlanders event. Johnny Messer's uncle is Billy Messer. Elvis Fields previously lived with Johnny Messer's uncle in the Rushville, Indiana area. So Elvis, that's another connection. Elvis Fields used to live with Johnny Messer, or sorry, Johnny Messer's uncle. Um, so it's a winding twist of family trees with the Vinlanders. So Billy Messer. So Elvis Fields previously lived with Billy Messer, and so Billy Messer probably got his roommate or previous old roommate to get with Elvis Fields. The two of them get together, and then Johnny Messer wants to recruit them. And maybe some ritual happens on February 13th, 2017. However, one of the most important aspects of the Johnny Messer evidence is Messer's role as a recruiter in the Vinlanders. According to former Rushville Assistant Police Chief Todd Click, Messer denied recruiting members for the Vinlanders. However, Click also testified and he had interviewed multiple men who admitted that Messer had recruited them to join the Vinlanders. Messer's denial of being a recruiter for the Vinlanders juxtaposes against Click's investigation revealing that Messer was in fact actually trying to recruit members to the Vinlanders who would indicate that Messer felt he had something to hide. What could that be? The obvious answer would be Messer was the recruiter that hooked Elvis Fields up with Brad Holder. After all, Messer knew both Holder and Fields, although Fields denied knowing Messer. See, they can't get their story straight on who they know and who they don't know. The fact that Messer's former girlfriend, Taylor Hornaday, told Kevin Murphy that around Valentine's in 2017, the Messer was up there, quote unquote, visiting his Vinlander friends, Westfall and Holder, and that a red substance she believed was BLOD was found on the car that she drove up there, provides additional connectivity between all these parties and the homicides, and that Richard Allen's constitutional rights for a jury to hear those connections. So it's infringing upon his constitutional rights that the jury isn't hearing those arguments. Excuse me. Oh, we're almost done. This is a long one. All right. So Keegan Klein and Jerry Anthony Klein. Keegan is the son of Jerry Anthony Klein. He was 22 years old in February of 2017, and he and Jerry Anthony Klein resided in Peru, Indiana in February 2017. Detective David Vito testified that Keegan Klein was communicating with Liberty German using a fake Snapchat account under the name of Anthony Schatz in the days leading up to and on February 13th, 2017. The uh, content of these messages is unknown. He further testified that Keegan Klein admitted to driving to Delphi, Indiana, with his father. So, okay. Um, not sure how the two are related, but okay. I'm still trying to grasp it here. Okay, so he further testified that Keegan admitted to driving to Delphi, Indiana, with his father, Jerry, on the 13th, and that Keegan Klein waited in the vehicle while Jerry Anthony Klein went into the woods in the area where the Abigail and Liberty German's bodies were ultimately found. So let me read that again. He further stated that Keegan Klein admitted to driving to Delphi, Indiana with his father on the 13th, and that Keegan Klein waited in the vehicle while Jerry, his dad, went into the woods for a short time and came back. Um, but he went into the woods ultimately close to where the bodies were found. Detective David Vito testified that Keegan Klein stated that when Jerry Anthony Klein returned to his vehicle, he had BLOOD on him. Roland Purdy further testified that Keegan Klein admitted that they discarded a knife in a river when they were driving home. So Roland Purdy is another law enforcement officer, I think. And Roland Purdy, no, I don't know. That name sounds familiar. I'll have to do a deeper dive and see if I can find out more about him because I don't know who he is. But I've seen his name pop up. But anyway, so Roland Purdy testified that Keegan Klein admitted that they discarded a knife in the river when they were driving home. So why didn't anybody go and search the river or do anything? All of this evidence creates an inference that Keegan Klein and Jerry Anthony Klein took the lives of Abby and Libby. Ron Logan. Bodies of Abby and Libby were found or were located on February 14th on the property of Ron Logan. Logan lied to law enforcement about his whereabouts in February 13th. Ron Logan's physical build is consistent with that of the individual in the video captured by Liberty German's iPhone, the down the hill phone. And his voice is consistent with that of the voice of the audio. So Ron Logan, who is deceased now, but he has there's a good reason for probable cause on him, let's just say. All right, so much like the facts in Allen, the case that was referenced before, Allen versus State, the evidence that the third parties took the lives of the girls in this matter is exculpatory, unique, and critical to Mr. Allen's defense. The crime scene included many findings that the killers practiced acid true and that it was the realistic crime scene. It was a realistic crime scene. To be exculpatory, evidence must clear or tend to clear Mr. Allen of alleged fault or guilt. Let me try this again. I am getting so tired. This document is so long. My brain and my tongue. Blah. Water break. Everybody hydrate. To be exculpatory, evidence must clear or tend to clear Mr. Allen of alleged fault or guilt. Simply put, if someone else committed the crimes, Richard Allen did not. Richard Allen has zero ties to Acid-True, Odinism, or the Vinlander Social Club, unlike Brad Holder, Patrick Westfall, or Johnny Messer. It's wild that these kinds of things exist right now, but they do. And it's just another way for oh God. I'm sorry. I gotta get through this. All right, so the above evidence is exculpatory, unique, and critical to Mr. Allen's defense. The above evidence that the state wants to hide from the finder of fact or the jury is admissible for two reasons. It demonstrates the lack of investigation and failures within oh my God. Stop it. It demonstrates the lack of investigation and failures with the investigation, and two, the fact of a distinct possibility, if not high probability, that people other than Richard Allen took the lives of Abby and William and Libby. Richard Allen has a right to introduce evidence as motive as it is always relevant. Evidence of motive is always relevant in a criminal prosecution. I need a stretch break. Give me 1 second. All right. Sorry about that. I had to stretch, sit up a little. All right. So, evidence of motive is always relevant in a criminal prosecution. In the context of third party motive evidence, an accused must show some connection between the third party and the crime before the evidence is admissible. And like we've been saying, there is a connection between uh, Logan Holder, Brad Holder, and Abby Williams. Excuse me. All right, so in the context of third party motive evidence, as um, in the context of third party motive evidence, an accused must show that there's a connection. In this case, the prosecution has no proof of any connection of Mr. Allen to Abby and Libby, nor have they identified any motive as to why Mr. Allen would take their lives. There is absolutely no evidence as to Mr. Allen's motive to commit the crime. What does exist, however, is motive on the part of Patrick Westfall, Brad Holder, and others to take the lives of Abby Williams and Liberty German. Brad Holder knew that Abigail Williams as Brad Holder knew Abigail Williams as his son was dating her at the time of the homicides, and he had supervised them on at least 2 dates, according to his latest statement. Patrick Westfall participated in animal sacrifices, and it is presumed maybe others did with him because uh, he said that he wanted to progress and make it human. As the true sacrifices are carried out in order to provide the offender with power. Power through runes, through BLOOD and binding runes, all of which are present at the location where the bodies were found. This provides motive for Brad Holder and Patrick Westfall to take the lives of Abby Williams and Liberty German as part of an true Odinist sacrifice. Wherefore, for the reasons identified above, Richard Allen, by counsel, respectfully requests the court deny the prosecution's motion in limine as it relates to Odinism, cult, or ritualistic KI-double-Lling, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Anthony Klein, or that's Jerry Anthony Klein, or Ron Logan, or for all other just and proper relief in the premises. So they're saying don't allow the state's motion in limine. We still haven't heard a ruling on this as of yet. I'm sure we'll hear something in the near future about it because I think she has 30 days to rule on it from the trial or the hearing that they had, I think. I'm not sure. All right, so here is the latest filing. This was just put on the docket. This is a cease and desist letter that was sent to the Allen County Superior Court and the clerk of Allen County, state of Indiana. So let's take a look at this. This is interesting and kind of baffling. Administrator. Dear Ms. Williams, not to be confused with Abigail Williams. This is just oh, hold on. Wait a minute. Let's take it back a sec. Let's take it back a sec. Let's go to the exhibit first. Let's do this. All right, so we're gonna use we're gonna go through this exhibit. It's an email exchange between Jennifer Marvin, who is contacting. She's with Beyond the Evidence, so she might be an investigator or something like that. Jennifer Marvin, and Jody Williams is apparently someone with the Allen Superior Court. So, where's the question here? All right, so good morning, Jody. I would like a copy of the transcripts from the hearings on July 30th, July 31st, and August 1st for the Richard Allen case. The State of Indiana versus Richard Allen, please advise on how I can obtain these transcripts. Okay, this is the response to her. Good afternoon. Based on hearing length, 21 and a half hours of actual in-court time, the estimated page count is 750 and estimated cost is $4,312.50. That is $5.75 per page. I require a down payment of 50%, that's $2,156, to secure preparation. The balance of the cost will be due upon completion. Upon payment in full, the transcript will be transmitted to you. Please be advised the above amount is an estimate only. Actual cost of payment may vary from this amount. Payment can be made in cash, cashier's check, or money order. Estimated preparation time will be at least 4 to 6 weeks, as I have transcripts for appellate cases that must take priority over all other requests, as well as the fact that this is a very long hearing. Well, so that's not their problem. They shouldn't have to wait longer just because it's a long hearing. All right, so if you are interested in proceeding with preparation, please let me know and I will give you further instructions on completing the down payment process. Okay. She writes back from Jennifer to Jody, why is it $5.75 a page? Jody responds, because the transcript has to be typed. If one has to be prepared, then a copy would be available for $1 per page, but no one has ordered one, and so if you would like one, you have to pay for the work required to prepare it. Is that fair? Is that right? No. The page per rate is set by local rule. Okay, that's her explanation. Great. Moving on to this cease and desist letter. Dear Ms. Williams, I am writing to address a serious concern regarding the fees being charged for the preparation of court transcripts by the Allen County Superior Court. It has come to my attention that the current rate being charged is $5.75 per page, which is significantly higher than the fee cap established by Indiana state law. According to Indiana Code 333751, the fee for preparing a transcript or copy of a record should not exceed $1 per page. The state law, $1 versus $5.75. So you're talking $750 versus $4,300 they're trying to charge. That's ridiculous. So the state law takes precedent over any law, uh, waiting for my dog to sit down and stop making noise. The state law makes precedent over any local rules or ordinances, and any fee structure that exceeds this limit is both unlawful and unenforceable. In your email dated August 7th of this year to a third-party individual, you stated, based on hearing length 21 and a half hours of actual in-court time, the estimated page count is 750 and estimated cost is $4,312.50. That's $5.75 per page. This rate is in direct violation of aforementioned Indiana state law. So it violates the Indiana state law, which takes precedence over any local law. Furthermore, you mentioned the per page rate is set by local rule. However, local rules cannot override state law. Charging $5.75 per page is not only unlawful but also unethical, as it leads individuals into believing that such fees are permissible. Because Yeah, if you're charging that, people are like, oh, okay, no problem. But they have no idea that the law says you can only charge $1 per page. So people have been overcharged for how long now? Additionally, you indicated that an out of state individual requesting documents would need to pick them up in person, stating that individuals would have to go in and pick them up in Indiana in person, as it is too much to mail. According to the Indiana Access to Public Records Act, or APRA, there is no provision that prevents the emailing of documents. So instead of mailing them, lady, get off your butt and put them in files and email them to this person. In fact, the law allows for records to be provided electronically if requested. Federal FOIA guidelines also support the provision of records via email or other electronic means. The Indiana Access to Public Records Act requires a response to requests within 7 days if the request is made by mail, fax, or email. So a response needs to be given within 7 days. Failure to comply with this time frame is a violation of state law. Moreover, the Eighth Amendment to the United States Constitution, which prohibits excessive fees, applies to state and local governments. The Supreme Court ruling in Timms versus Indiana reaffirmed that the excessive fines clause is incorporated against the states. Charging $5.75 per page for transcripts could be considered an excessive fee, violating both state and federal constitutional protections. Holy hell. You guys are in trouble. Therefore, I am formally requesting that the Allen County Superior Court immediately cease and desist from charging more than $1 per page for transcript preparation. Whoever was getting that payday, your payday's over. That's ridiculous. $5.75 per page. Continuing to charge fees in excess of the state mandated limit constitutes a violation of Indiana law and could result in civil and potentially criminal contempt charges for misappropriation of funds. So now you're talking some other criminal charges now for contempt, misappropriation of funds. We're talking some serious charges now. It's not just we did a little overcharging. Oops. No, this is against the law, what they're doing here. Furthermore, if the court has ever charged any individual's fees contrary to this law, contrary to the $1 per page, so if they've charged anybody at any point more than $1 per page, they need to return it. I am asking that this information be made public and that those individuals be reimbursed for the costs they should not have incurred under Indiana law. This might even affect content creators' criminality and the Defense Diaries, Bob Motto, because they often pool money together and purchase transcripts so that they can make them available to the public, which is ridiculous that they're not anyways. But I wonder if that affects them. I wonder if they had to be, if they were overcharged for those transcripts in the past. I wonder if they'll be getting any legal notice that they're going to be reimbursed. That would be interesting, huh? All right, so regarding the criminal case of State of Indiana versus Richard Matthew Allen, the hearings on July 30th and 31st and August 1st took place in Carroll County Circuit Court with Judge Francis Gull from Allen County Superior Court sitting as a special judge. According to Indiana law, a special judge appointed by the Indiana Supreme Court retains jurisdiction of the case for all future proceedings unless a specific statute or rule provides otherwise. Therefore, it's the Allen County Court clerk who would assume jurisdiction over the responsibilities and not the Carroll County clerk. Therefore, Allen County clerk would assume jurisdiction over the responsibilities associated with providing a record and a transcript and collecting fees for this case. Please confirm receipt of this email and provide assurance that the necessary adjustments will be made to comply with Indiana state law. Thank you for your attention in this matter. Anthony Guarino, True Crime Investigates. And I believe he's probably like a PI or something. His name's familiar. I just can't remember um, where heard it before. But yeah, so that is, you know what? I'm going to look him up. Hold on one second. Hold on one. Well, what do you know? This is Anthony Guarino. I had no idea. He is a producer. He did Murder on the Monin, which looks like a TV miniseries, crime documentary, Murder on the Monin, local investigator and true. This is his IMDb page. Local investigator and true crime personality Anthony Guarino explores a complex web of suspects and personal challenges while investigating the tragic murders of Abby and Libby in Delphi, Indiana, in a compelling true crime series. So you can add it to your watch list. I'm not signing into IMDb, but that is who he is. So he is a local investigator and a true crime personality. I think he's I was trying to find if there was more info about him. I guess he has a YouTube. Yeah, he's got a YouTube. Oh, no, he doesn't. This page is not available. Okay. So anyways, I don't know. Maybe he had a YouTube at some point. Anthony. Maybe he changed his YouTube. No. True Crime Investigates. Not found. Okay. He just, well, if maybe he changed his YouTube page or they shut it down on him because it's not coming up. Um, but whatever this says, he's some kind of investigator, and that's all I know. Investigator and a true crime personality, they called him. But then people are like tearing him down and saying, like, who is the real Anthony Guarino? So I don't know. I'm just reporting what came out in the docket today. I was trying to see if there was more information on him. You know what? Let's do a quick search of his name. Let me do that. Hold on. Okay, well, I did a quick search of his name on Reddit, on this Delphi Ducks Reddit page or community, whatever you call it. Yeah, community. And they have, this is from 3 years ago. It says there are unconfirmed reports that Anthony Guarino has been arrested. Somewhere it says Anthony Guarino removes his content from YouTube, turns himself in for parole violation. That was 3 years ago. So I don't know what that's about. I don't know anything about him. I just know he provided a letter to the um, Allen County, Allen Superior Court to let them know that they're charging too much. So that's insane though. 575 per page. Does anybody know what your county's charge? I mean, that's ridiculous. I don't know. I've never tried to get a transcript paid for in my county, but I wonder. I should look into that. Let me know what you guys think about this. I know this was a longer episode, but we had that Delphi memo of law was lengthy, but it was good because it went through all the different individuals and how and why they should be able to argue regarding those individuals' potential involvement in the crimes. So, who do you think is most likely? the individual who or individuals who are the perpetrators in this crime, let me know in the comments below. And thank you guys so much for watching. I'll see you in the next one. Take care. Bye now.